So I'm going to do a case here to talk about a Florida Probate Appellate Court case. This one called PLAC versus Regal. Just comes out of the 5th DCA that's down in the Miami area just yesterday. One of the interesting things about probate is despite the fact that people have been dying in this state for a long time, and we've been probating cases for a long time in this state, there's just not a real big universe of appellate court cases. And where that is so important is in the day-to-day life of probate practitioners and lawyers. In most other areas of the law, there's a well-developed universe of appellate cases that tell us with precision exactly how a judge is supposed to resolve an issue. But probate is very much the same of where I spent my world in the foreclosure world. So I spent decades doing foreclosure cases. And at the beginning of that effort, 2008, 9, 10, I was one of the earlier ones, there was a real small universe of cases that were directly on point. So we started off, analogizing different cases to explain to the judge what's supposed to happen in that foreclosure case. Well, as foreclosures exploded along in frequency, there were more and more appellate cases. I was appealing left and right, and other practitioners were appealing left and right. And in a pretty short order, where there was a real lack of cases in the universe, there became a huge universe of cases dealing with foreclosure. That's going to start happening in probate world. There's a lot of money at stake. There's a lot more people willing to fight. And so you're going to see more and more cases dealing with appeals in probate cases. But in this particular case, PLAC versus Regal, dude Ronald died in 2015. Someone had prepared a petition claiming that he executed a will in the 2000s, but the original were lost. Another important point, probate and wills are one of the last areas where original documents are required. But when that thing was signed back in 2016, these consents, they were never filed in court. But then, fast forward to 2022, and then in 2024, competing petitions were filed. One for intestate, or you don't have a will, and then a second one claiming that the lost will was important. The testimony that was apparently admitted apparently led that judge to believe that the lost will should have been admitted and considered by the court. But as the appellate court determines, they found that the trial court did not properly establish the conditions for admitting a lost will. And that's really important to pay attention to, because under Florida Statute 733-207, you got to show that a correct copy of the will exists. And then the contents of that will has to be proved by the testimony of a disinterested witness, someone with no stake in the outcome. And that really becomes a challenge. Lawyers, I think they could be good witnesses. The notary, the witness signatures, those are good disinterested witnesses. But the correct copy, it must be an original of the identical lost will. These consents that were filed in this case, the appellate court says doesn't work, and for these reasons. Number one, the 2016 consents were not filed with the court. Maybe if in 2016 those consents had been dropped in there, the analysis would have been different. The consents didn't challenge the right to file the will later. Another key point in that case, apparently the disinterested witness wasn't disinterested because they were a party or were going to take under the will. They didn't know the contents of the will. They didn't see it at execution. So what the appellate court found was that the black and white statutory law, 733-207, just wasn't admitted. Why does this matter? Well, we got an original will, or we got a lost will. We had to go through an exhaustive effort to search down witnesses, disinterested witnesses, being real clear about who those disinterested witnesses are, being clear about what copies exist, and can it be authenticated as an original copy. The other huge element is this presumption. In law, presumptions are hugely important, and in this one, when the original is lost, the presumption is that the person intended to rip that thing, throw it up, have no force or effect. That was missed in this particular case. That's why the appellate court reversed. Now, obviously, there must have been something big at stake for these cases to be filed, 2016, 22, 24, and now in 26, just finally getting resolved. So Paying attention to the basics, knowing where that original will is. Did it get filed? Did it not get filed? Did it get destroyed? Destroying copies, making sure revocation is super clear are the important things. But the large lesson about all this is we're going to see more and more appeals in probate cases, and that's going to govern a whole lot of practice. There's too much trial court practice now that doesn't have a good record. That's one of the basics and the foundation of due process is making sure we got that appellate record that will support a successful appeal.